Modern lawyers need to understand different ways to resolve disputes. The Dispute Resolution and Lawyers Videotape series is designed to provide instruction in negotiation, mediation, and other alternative methods of dispute resolution. The 4 videotapes are suitable for training both lawyers and judges and for use in law school courses on dispute resolution, the lawyering process, and professional responsibility. In addition, each tape has been specifically designed for a particular first-year law school course: contracts, property, torts, or civil procedure. Tape 1 shows the negotiation of a medical malpractice claim and fits into the torts course. Tape 2 is a contract negotiation and works well in the contracts course. Tape 3 demonstrates a mediation and is suitable for property or contracts courses. And Tape 4 shows a lawyer interviewing and counseling on alternative dispute resolution, and then proposing ADR to an opposing lawyer. It was designed for civil procedure or torts classes. It would also be useful in a course on client interviewing and counseling. Each tape is based on a simulation from the instructor's manual for the Dispute Resolution and Lawyers Casebook, written by Leonard Riskin and James Westbrook and published by West Publishing Company. Each tape also comes with its own instructor's manual, which includes simulation material, a transcript, and teaching suggestions. The series features role plays acted out by accomplished professionals and uses graphics and extensive narration to reinforce the teaching points. Each is designed for use in a 50-minute law school class.
Most lawsuits are settled through negotiation. What follows is the negotiation of a medical malpractice claim by 2 experienced lawyers who chose to have their clients present for parts of the negotiation. Commentators have identified 2 different approaches to negotiation: adversarial and problem solving. In adversarial negotiation, the parties seek to divide up a fixed resource such as money or land. What one gains, the other must lose. They tend to focus on positions, that is, specific demands or offers.
Tape 1 illustrates the differences between adversarial and problem-solving negotiation and shows how lawyers can effectively integrate these 2 approaches. It also shows the advantages and disadvantages of involving clients in negotiation and raises questions about honesty in negotiation. The fact pattern itself raises legal issues concerning informed consent, negligence, and damages.
She has actual damages, Jim, of $80,000. And in view of the highly doubtful liability in this case, reasonable settlement would be to just say that the liability is doubtful. We'll just consider it a 50-50 shot on liability, and a reasonable settlement of the case would be in the not to exceed $40,000, half of her actual damages. And that's what I would think that I'd be willing to consider that she should think about.
Well, sorry, we're miles apart.
We sure are.
I think what's going to be important here is credibility of the witnesses. And what I'd like to do, I did bring Mavis with me, have an opportunity to meet her. And then I'll talk to her about, am I assuming the 40's an offer?
No, I don't have any authority from my client to talk about any figure. I don't have authority to make any offer at all because my client thinks that she performed proper medical care and she does not believe it's a case of liability, Jim. I'll have to talk her into a settlement of the case.
Later in the negotiation, both lawyers brought in their clients.
You gave this lady no choice, as I understand it, and you correct me if I'm wrong, of any conservative treatment. And I'm assuming you didn't because you didn't ask her what her profession was. You didn't know she was a concert pianist, a jazz pianist. You give her this shot, and she ends up with the sequelae that is indicated in the PDR.
Well, I think you're making a lot of assumptions that just aren't true.
Well, that's what I want to know.
First of all,
after this session and following private meetings with their clients, the lawyers negotiate an agreement that responds to their clients' needs. The second tape shows 2 lawyers negotiating a supply contract for cardboard boxes. This tape, like the first, explains and illustrates the differences between adversarial and problem-solving negotiation and raises issues about deception. But it differs from the first by showing how an overemphasis on adversarial techniques, combined with misleading statements, can sometimes lead negotiators into deals that do not satisfy their clients' interests. Here is an excerpt from the adversarial portion of the negotiation.
The basement price that I've been given is $1.35 a box.
Well, I'll be honest with you. I think that's an unfair price. I think that you're taking advantage of us, but under the circumstances, I'm going to go ahead and I'm going to accept that price on behalf of Glasgow.
Well, Kate, you're not going to regret this. You're going to find that your customers are going to be very happy with you, that you will have very little breakage, you'll have very little complaint, and
Harry, we better not have any breakage with these boxes at $1.35 a carton.
Well, let's move on to other terms. You've said 6,000 cartons a week?
6,000 a week. Here, you do understand that I want these starting in 2 weeks.
Yep.
And this will continue for a 6-week period. Basically, that's all I'm interested in at this price. So
6 weeks. What about beyond 6 weeks? What happens then?
Well, we're not interested after 6 weeks. At $1.35, that's out of the question. So basically, I need 3 deliveries every 2 weeks, 6,000 per week. So that would be 12,000 per delivery.
My management's
We'll
not going to
pay
be
cash.
very happy with this. I can tell you.
What do you mean your management's not going to be happy at $1.35?
$1.35 is fine short term, but we're as I said, jeopardizing our current market share and the current market segment that we're serving, putting on people in addition to our normal workforce.
What are you saying? You want a longer-term contract?
I think a longer-term contract is certainly what what Quality Carton had in mind when we began these discussions.
Well, I'll be honest with you. Glasgow had a long-term contract in mind too, but I haven't been, real pleased with the way in which these negotiations have gone. $1.35. I understand your position. I understand that your company can't do it for less than that, and that's your bottom line. But obviously we can't accept that. We have an alternative supplier that can give it to us at a substantially lower rate than us. We need them for 6 weeks. That's it. Any other terms we need to discuss?
After the session we have just watched, both attorneys reported to their clients. The clients were disappointed with the proposed agreement and asked the lawyers to continue negotiating toward a more suitable long-term arrangement.
The lawyers resume negotiations, begin to use problem-solving techniques, and are then able to reach a better agreement.
Mediation is an informal process in which the parties to a dispute or their representatives seek to negotiate a solution to their problem with the help of an impartial third party. Unlike a judge or an arbitrator, the mediator has no authority to impose a solution. Instead, the mediator facilitates and structures the communication between the parties. The process usually results in an agreement.
This tape demonstrates the mediation of a dispute concerning a commercial lease. In this case, the tenant planned to open a franchise restaurant called Red Devil Dog. After the lease was signed, however, the franchisor went out of business, so the tenant told the landlord she would not be able to rent the property. The landlord has demanded payment of the total rent that would have accrued under the lease, and he is holding the tenant's equipment. The tape is organized around 5 tasks or stages in mediation. Each stage is illustrated in the role-play segments and is further explained through graphics and narrative. The tape demonstrates many techniques of mediation. The next segment shows how a mediator can help the parties negotiate by identifying their goals.
I'd really been wanting to do this, and I was very honest in my intentions to do it. So I went ahead and I gave him a $2,000 deposit, and I'd like that back. It
What
wasn't
she really wants
called
to do is
for.
to walk away from this deal. Did you notice that? Just give me back my equipment, give me back my $2,000. Bye-bye, Mr. Landlord. That's her story.
You're right, and what have you lost out on? That place has been empty forever. I had no idea that the corporation was going to go bankrupt. We agreed
Yeah,
that
it's a
I would have a
contract.
lease.
It's
I had
a
a
lease.
lease to
Hold it a
perform
second.
to have a
Hold-
Red Devil Dog restaurant.
Hold
I
everything.
can't.
Hold everything.
It's not my
It
fault.
Sounds like what we're talking about is that you're both interested in ending the relationship, and that Anne really wants her equipment back quickly, and Frank wants some money.
The mediator also holds private caucuses with both parties.
Did you write the letter before you saw your lawyer or after you saw your lawyer?
I wrote it after, but the lawyer didn't help me write it. I just figured, well, you know, if you're going to take a stance, let's take a strong stance, a sort of a negotiating posture or whatever you call that.
I see. And I gather you've been in business for a while, and that's one of your strategies, to come on pretty strong when you're negotiating?
Well, yeah, I don't let people walk all over me. In other words, I figure you let people know what you want them to do. You don't always get 100% of what you ask for, but why not ask?
Sure, I understand that. Yeah. Do you have any sense of how that affects Anne?
When the parties come back together, the mediator continues to help them overcome barriers to negotiation and helps them reach a final agreement. The fourth tape is based on a libel claim against a newspaper, its editor, and a reporter.
This videotape is intended to illustrate some possibilities and problems in helping a client select a dispute resolution method and persuading an opposing lawyer to participate. There are two parts. Part 1 shows a lawyer interviewing her client and counseling the client about alternative methods of dispute resolution. Part 2 shows the same lawyer discussing these alternative processes with opposing counsel.
In the beginning of the tape, the lawyer conducts an interview to learn about the facts and about the parties' underlying interests. She then gives an analysis of her client's legal position. Next, she reviews several methods of dispute resolution. She explains the binding methods of litigation and arbitration and the non-binding methods of summary jury trial, mini-trial, and mediation. She also highlights the advantages and disadvantages of each process. In this scene, the lawyer describes the disadvantages of the summary jury trial.
The problem with this procedure from the newspaper's perspective, as I see it, is that jury verdicts are often overturned, and if this verdict was favorable to Dr. Rourke, it could harden him in his position, encourage him to be very aggressive about the litigation, dig in his heels, and it's really not a realistic predictor, in my view, as to how the case would come out.
Ultimately, the lawyer proposes a mini-trial with a mediation component, and the client agrees.
I didn't suggest this meeting to posture, and I really don't think there's much to be gained by us getting into a discussion of the merits of the case. Really, the reason for my suggesting this meeting was to see if there was something we could do to help our clients avoid the entanglement of litigation and see if there wasn't some way that they could resolve this dispute more quickly and less expensively than litigation. And the reason that this came to mind is because, as I understand it, there may be some interests here, both of your client and of my client, that may not be able to be well served in litigation and may be able to be better served through some alternative dispute resolution mechanism.
Well, it's interesting you say you don't want to posture and then tell me my case has no merit, my client has no damages. I'll tell you this, my case does have merit, my client does have damages, and I believe that I can submit this case to the jury on punitive damages because, as you know, this guy isn't the owner of the building. That's clearly false. As you further know, there is a strong implication in that story that he or the owner burned that building, and I think that there's no evidence to substantiate that, and this case is going to go to the jury, and you know this case is going to go to the jury. Or I wouldn't be sitting here, isn't that right?
No.
So what other kind of relief are we talking about?
Finally, the lawyers agree to try the alternative dispute resolution method that the defense counsel recommended. Lawyers, experts on dispute resolution, and law professors collaborated to produce these tapes. The tapes don't just introduce alternative dispute resolution, they also help the viewers understand subtle aspects of each process. The content and structure of the tapes, the graphics and narratives, and the role-play simulation materials make the tapes effective for educating virtually any group of legal professionals, from law students to seasoned attorneys. The tapes can be purchased individually or at a packaged rate. For further information, contact West Publishing Company, Law School Department.